All right, welcome to this explainer. Today we're unpacking a truly fascinating, completely multidisciplinary analysis from the Grok Chat to LLM's documentation, and it examines a highly complex legal case. We are diving into a really unique set of documents that detail the prosecution and the subsequent self-defense of an independent scholar named Dr. Chen Jingyuan.
We're going to explore how a scientist literally used constitutional law, physics, and developmental psychology to deconstruct his own criminal conviction. What makes this source material so compelling is that this isn't just your standard legal appeal. It's a meticulously structured scientific defense, and it was written entirely from a prison cell.
So here's how we're going to break this down today. First, the empty indictment. Second, the constitutional framework. Third, the physics of information. Fourth, the accused's psychology. And fifth, analyzing the judicial system.
Let's jump right into part one, the empty indictment, formal compliance versus substantive emptiness.
The source analysis points out a pretty stark contrast here right out of the gate. On the one hand, you have formal compliance, meaning the document looks exactly like a proper legal indictment. It's got the names, the dates, the technical charge of picking quarrels, but on the flip side, we see substantive emptiness. Imagine being charged with a crime, but the legal paperwork completely lacks specific evidence. It cites no exact tweets and provides absolutely zero quantifiable data on any actual social disruption.
And this substantive emptiness sets the stage for a really controversial logical leap made by the court. Step 1, the defendant retweeted public posts. Step 2, the court presumed that because Dr. Chen has a high academic background, he must have intentionally spread false information. And Step 3, conviction without quantitative proof. Basically, his own high education was weaponized against him to completely bypass the need for hard evidence of intent.
Moving on to Section 2, the constitutional framework, paper rights versus judicial practice.
The source material systematically argues that this conviction clashes directly with specific constitutional protections. It lays out how penalizing the sharing of public tweets contradicts Article 35, freedom of speech, and Article 47, academic freedom. Plus, because only Dr. Chen was targeted while the original posters were not, it raises major questions about Article 33, equality before the law. And finally, when prison guards allegedly refused to transmit his letters of complaint, well, that directly challenged Article 41, the right to complaint.
This creates what the analysis calls a dual-track system. You've got these beautifully written rights, very solemn on paper, yet they become totally distorted and fail to translate into practical protections in reality. The source notes that this kind of selective enforcement ultimately undermines the authority of the Constitution itself.
Okay, part 3. This is where it gets really interesting. The physics of information, self-organized criticality, and avalanche dynamics.
The analysis actually brings in a concept from physics called self-organized criticality, or SOC for short. This is a theory used to explain how information cascades on social networks. It operates a lot like forest fires, avalanches, or honestly just what we call going viral online. In a critical state, one tiny spark, like say one small retweet, could hypothetically trigger a massive, system-wide avalanche. But here is where the math completely dismantles the state's indictment. In network physics, M represents the branching factor. That's essentially how many new people see and share a piece of information from one specific user. Well, the mathematical branching factor for the defendant's social media account, which only had a few dozen followers, was far, far less than 1. What this means in physics is that his account existed in a deep subcritical state. Any information cascade originating from him was mathematically guaranteed to go extinct. It was literally impossible for him to cause a social avalanche.
And the source beautifully contrasts the two actors here. You have the defendant as this insignificant edge node with low influence where a cascade is guaranteed to die out. But the judicial authorities, they act as a massive hub node. By bypassing laws and throwing around extreme institutional power, the analysis argues that they're the ones actually driving the system into a volatile, supercritical state. They're the ones risking a true system avalanche.
That brings us to Section 4, the accused psychology, a clash of development.
Looking at the psychological profiling in the text, it shows a defendant scoring incredibly high in openness to experience, conscientiousness, and emotional stability. And these aren't just psychology buzzwords. According to the source, this very specific psychological makeup is exactly what gave him the profound resilience to survive the trauma of imprisonment. Instead of a breakdown, he used his time to write a mathematically and philosophically rigorous defense.
This breakdown frames the entire conflict as a collision of developmental stages. You've got Dr. Chen functioning at a post-formal cognitive stage, driven by universal ethics and a fully achieved identity as an independent thinker, and colliding head-on with him is a judicial system operating at a highly rigid, formal cognitive stage, stuck in conventional morality where following the rules supersedes universal justice, all while relying on a foreclosed fixed identity of institutional authority. It's just a fundamental mismatch in human development.
Finally, Section 5, Analyzing the Judicial System, the Accusations of Structural Failure.
The documents impartially map out a timeline of alleged procedural violations here. The text outlines how the system essentially bypassed its own legal safeguards right from day one, starting with an arrest without a proper warrant, failing to notify his family, conducting secret trials, all the way to blocking his legal complaints months down the line.
Now, in his writings, Dr. Chen actually referred to the actors in his case as a judicial mafia. But what the source material does so well is it neutralizes those emotionally charged claims by systematically cross-referencing the alleged actions with specific articles of the Chinese criminal law. It maps the behaviors directly to abuse of power, extorting confessions, illegal detention, and bending the law. So it transforms a passionate, personal complaint into a highly structured statutory legal critique.
The analysis ultimately frames this whole situation as a massive systemic paradox. The charge of picking quarrels is described in the text as a vaguely defined pocket crime, basically a catch-all category. The real paradox is that this ambiguous tool was utilized to suppress a citizen who was displaying advanced cognitive maturity, deep intellectual exploration, and strict scientific rationality.
So, when a system prioritizes rigid compliance over hard evidence, and when it uses its power to silence complex, scientifically grounded voices, we are left with this lingering question. What happens to the future of a society when its rigid institutions punish the cognitive maturity and scientific rationality of its citizens? Thanks so much for joining me for this explainer today, and remember to always keep questioning the systems around you.